Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. And the content that I'm going to show you right now is, honest to God, what could be the beginning of the end of the NFA. There was a court case coming out of Kansas which has ruled and dismissed a auto charge because the government did not prove that there was historical analogs through the Bruin decision, so it's been dismissed. This is a big one, people. Everything I'm about to show you is going to be linked in the description box below, and send this one everywhere, because while it's still at the district court level, this has some serious potential. And of course, if you're enjoying the content, if you want to spread the Second Amendment to and fro across this beautiful nation, please make sure you hit that like button, subscribe to the channel, turn the notification bell on. And with that said, let's dive into this. Guys, this is a big one. This is not the Maryland case where the AR bans are going before potentially before the SCOTUS from FPC. This is a totally different thing. This is full autos. This is NFA. This is something to take note of. I'll put it to you this way. So what I'm showing you right now is an actual tweet thread on this decision. Okay. So as you can see, the guy that we're quoting here, this is Costas Moore. This guy is a actual attorney. I'm gonna throw it right there. He's an attorney for the CRPA. So this guy knows what he's talking about. Okay. Let's get into it, because, again, this is really exciting stuff to be alive in this fight. A machine gun possession charge was dismissed by a district court in Kansas yesterday on the Second Amendment grounds. That's huge, because the Second Amendment and the NFA are sometimes kind of at odds with each other. Well, if the National Firearms Act is found to be in violation of the Second Amendment, that'd be quite a thing. Let's continue. The court found that machine guns are clearly bearable arms. That is massive. And in this case, at least, the government failed to show a historical tradition to justify their ban. That's the Bruin decision. No historical analogs, it's getting thrown out. NFA requires historical analogs, it gets thrown out on Second Amendment grounds. That's kind of the perfect picture. That's where this ends. But guys, this is a heck of a starting point. Now, here's some backstory. This is in Kansas. This is in the 10th Circuit. The 10th Circuit is run by Gorsuch, Justice Gorsuch. Gorsuch has been pretty solid on a lot of the rulings that we've seen come out. He was key in the Chevron case, the Looper Enterprises case. He's been involved. So this is not like it's in Sotomayor or it's in Kagan in the liberal districts. This is legitimately, it's as good as you're going to get outside of Thomas, okay? Now, let me get in here and show you some other things about this specific tweet. This is the actual ruling itself, or the dismissal. Let me click on this and show you so we can actually dive in and kind of read what the memorandum in order is, and I'll show you the backstory. So, this is the case right here. Morgan, the United States of America versus Morgan, the defendant. This matter is before the court on the defendant's motion to dismiss based on Second Amendment grounds. I'll show you what he's doing in a second. A response and a reply have been filed, and the court held a hearing to establish additional facts about the weapons charged. The motion is thus ripe for review. The court finds that the Second Amendment applies to the weapons charged because they are bearable arms. It's a very important piece. Within the original meaning of the amendment. That's the Second Amendment. The court further finds that the government has failed to establish this nation's history of gun regulation justifies the application of the code. The court therefore grants the motion to dismiss. So, let me just there you go. Here's what he was doing, okay? And this is the important piece, because this is what they tried to pinch him on. Defendant Tamori Morgan is charged with 2 counts of possessing a machine gun in violation of the code. Specifically, the defendant is charged with possessing an Anderson Manufacturing Model AM-15 300 caliber machine gun and machine gun conversion device. So that's Glock switches and that's auto sears. Okay, that's basically what we're dealing with. So in this case, the government could not prove there was historical analogs to banning NFA items. That's the key takeaway. And as a little bit of an Easter egg, I found this interesting. One of the weapons involved was a Glock Model 33, a 357 SIG caliber firearm to fire as an automatic weapon with a Glock switch, which is, I find, it's quite an interesting choice. 357 SIG. You don't see it a lot, but if you're going to do it, I mean, I guess do it. But let me zoom out and show you the other piece to this, because again, there's lots of elements to this, guys. This is a really big piece. This is a follow-up post that he did. It looks like the government barely tried to meet its burden, relying on the Heller dicta instead. This is exactly what happened in U.S. versus Kitson, except the district court is that let the government win. We submitted an amicus brief on that one, and I'm going to click this open here to show you this piece as well. To summarize, in this case, the government has not met its burden under Bruin and Rahimi to demonstrate through historical analogs that regulation of the weapons at issue in this case are consistent with the nation's history of firearms regulation. That is the Bruin decision. All day, every day. The Bruin decision may just have gotten us the first full auto questionable case that can go to the next levels. Now, we're not at the highest circuit court levels, not even getting near the SCOTUS just yet. It's going to take time for this to develop. But what we're dealing with right now is at a district court level. This is very similar to the Reed O'Connor rulings that we covered with all the other things the ATF tried to do earlier this year and the prior. This is a thing. All right, let's keep going. Indeed, the government has barely tried to meet that burden, and the Supreme Court has indicated that the Bruin's analysis is not merely a suggestion. You'll love to see it. Now, again, where we're sitting with this ruling is at a district court level. Again, I'm going to show you what he's saying objectively here in a second, and I agree with him. We're at a district court level where an NFA item and item charge of possession of a machine gun has been thrown out on Second Amendment grounds based off of Bruin and Rahimi. And machine guns, as they would call them, or full autos, or whatever you would call it, in this case, would be underneath bearable arms. Well, bearable arms is protected within the Second Amendment. If this happens to go further, is this the vehicle that undermines the entire NFA? I mean, guys, we see NFA is going to die all the time on these videos. This one actually, like, legitimately, it is laying the groundwork. But now, let me show you what he said at the end here. Again, this is an important piece. Lots of excited responses, but everyone keep in mind that A, this is a district court ruling and can be appealed. That's very true. It's going to be appealed. The DOJ is going to get involved in this because they can't have this stand. That cuts against their power. They don't like that. B, even this court didn't rule out that another case could go differently if the government actually tries to put forward historical analogs. Personally, he doesn't think analogs exist. They don't exist. I mean, it's flat out they don't exist. But this piece here, even though the court didn't rule out that another case could go differently if the government actually tries to put forward historical analogs, what he's saying is it went from a completely different angle, which failed. So, worst case scenario, say this goes to the next level and this gets smoked. The worst case scenario here is that they lost on the Heller dicta, and now they're talking about the actual Second Amendment grounds and historical analogs to satisfy the Bruin decision. That's the next step in a different court of opinion. Now, where we're at right now, you've got a win. You've got the NFA that was just dealt a serious blow in credibility. You have a Second Amendment challenge to full auto bans and basically the NFA underpinnings. This is a big deal, guys. This is the very beginning stages, but this one will be watched going forward. This is something you need to spread out and you need to send to everyone you know because they need to know about this one. This one has legs. And that's what I've got for you guys. Let me know what you think in the comments below, and I'll see you on the next one. I'm Braden. See you later.